Good morning, good afternoon, good whatever time zone you're in. I don't know what time zone I'm in. I'm in a time zone that doesn't change time zones, but my time zone changes time zones. I don't know. What day is it? I think that it's Thursday. It's February 6th. I'm not ready for it to be February. I don't know how you feel about that situation. I am not ready for it to be February. But today we've got a travel stream because there was court in Massachusetts. Emily, would you normally stream if you're traveling? I always say that I'm not gonna. And then stuff happens, the law is busy, and I ended up being like, well, we'll just go to court. So today we're going to go to court. We're going to zoom into Massachusetts because I am dying of curiosity about what the attorneys argue here. For those of you that are like, I need the TLDR, don't worry. We're going to roll the intro. I'll give you the TLDR of what I'm expecting in court today. We are a little behind real time because I am not in a time zone close to Eastern. And so I also concerted last night. So there was no 9 a.m. in court for me this morning. I work for myself, so I'm not beholden to court schedules. The judge is like 9 a.m. Eastern. I'm like, sweet. We'll address it sometime after 3 p.m. Central because that's going to work better for me. So we're going to watch through this hearing today. We'll do a TLDR after the intro. Yes, had a great time at Jelly Roll last night. Yes, in Arizona while the waste management is going on because there are some great concerts and a lot of friends that live here in Arizona. So we're doing all the things. Emily, are you watching golf? No. No, I know there's supposed to be a golf tournament going on, but there's like concerts and parties. So no, not golf, concerts and parties. That's what we're doing. No, we're not doing the golf. And when my friend Amy was like, do you want to go watch some golf? I'm like, I mean, no, but I'll sit on a patio near a golf course if we would like to do that. Cause right now the weather is lovely. The weather is lovely. So like, yeah, it's fine. Everyone else can watch the golf. We'll just sit and do the things. I was at Innings Fest last year. I was at Innings Fest because Dave played and it was great. I showed up just in like second song in for Dave, like in for Dave and then like back out. So let us get into court today. Emily, roll the intro, do a TLDR. I'm going to keep hydrating because desert. We're in the desert is just, all of my skin is so dry. Because desert. Emily, you do nothing but complain about how dry the air is in the winter. Yes. Emily, you complain that the air is too wet in the summer. I mean, also, yes, I grew up in California. My body is finally attuned to between 65 degrees and 75 degrees, and anything outside of that range with a good, like, at least 25% humidity, I've like dialed outside of my comfort zone because I did not grow up with a very big threshold for weather. Obviously, it broke me. I'm getting there. All right, law nerds, let's roll the intro. Let's go to court. And if you hear any background noise, it's because the door's open and it's lovely. So it's me, not you. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, I should say, before we go to court, I promised a TLDR, and then I was getting all ahead of myself. I hope you heard that. It did not work great on my end, but on your end, it's fine. Let's do a quick TLDR. So I broke down the defense motion. I did not break down the Commonwealth's response to the motion. We'll hear the Commonwealth's response today. I just didn't have the time. Emily, I can't believe you didn't break down the Commonwealth's motion. For whoever on the replay crew feels that way, go find it and read it. It'll be fine. I have not had time. We have been traveling. The Commonwealth is going to say, not on us. So some form of not on us in writing is what you're going to get from the Commonwealth's response. The defense motion today is regarding their expert fees. Remember, the court was holding aside today for a hearing if an evidentiary hearing needed to happen for the tech expert. The court said, I'll decide this matter without a hearing. I broke that down on Tuesday's episode of The Emily Show, which lives on the Quick Bits channel. It's the podcast. It's not always quick. It's quick-ish. It's quick adjacent sometimes. Look, the rest of the bits are quick. I can't make any promises about the podcast anymore. It's Emily, I thought this was like a 15, 20-minute thing. Why is this episode an hour long? Well, there was much to talk about. Every story was 15 minutes. There was much. So the Commonwealth is going to say some version of this isn't on us. The defense is saying, look, we flew our expert out to Canton. We did it at our expense. We were led to believe that this information existed in its original state on the DVR at Canton PD. And the defense wanted to download it. The defense says, we keep getting bits and pieces of video. So at some point, you saved video and you're just like dripping out all these little pieces of video. We should have access to all of the video. It should have been preserved. It should have been turned over. We think it's exculpatory. The defense, I have not seen their motion to dismiss filed yet, but it is due this week, and we will see a motion to dismiss being filed regarding whether or not this is exculpatory, whether or not this is Brady. Remember, you can have discovery issues that are not Brady issues, and if you have discovery issues that are not Brady issues, they can have some different remedies than if they are Brady issues. Brady issue is very fact specific. And you will remember when we went through all of this in New Mexico, the court was very clear that something being impeachment of a witness is not necessarily exculpatory. And there's a lot of case law around what is and is not exculpatory. So there's more of a fact situation that needs to be, that we need to delve into. And I just don't have enough of the facts yet to dive into that. But my gut is like, well, I need to know more and I need to hear more about this. Today, we're going to hear some of it, and then we will get when the defense files their motion to dismiss and or when the motion to dismiss is filed with a response from the Commonwealth, then we will go over it together. So with all of that, we are on a delay from the morning due to travel. So if anyone is here that has already watched this hearing this morning, thank you for no spoilers. Thank you for no, oh my God, this is what they're going to say next. We appreciate it. I know a lot of the law nerds waited to watch it together with us. Some of you watched it and are back to see, Emily, I need your take on this. Perfect. I appreciate you. Law nerds, you're the best. We're here. Let's go. Let's go to court and like, hear ye, hear ye. I feel like because we're not all in Massachusetts, we need to get there together. So, you know, buckle up, tray tables in their locked upright position. Delta now has free YouTube Premium if you are a Delta member when you fly on Delta flights. So you can watch the EDB live stream from your flight right in, you know, in your seat back on YouTube Premium for free. Amazing. Let's roll. I know. For all of you that says, we waited for you, I know. Casey said, I waited. It's not the same without EDB. I appreciate that. I appreciate that a lot of you are like, I mean, court is court, but without the commentary, I don't know if I want to watch. Like, because court is court. Because court is court. For those of you saying my audio is kind of low, let's try to bump that up just a little bit. For those of you that are like, the Delta stuff is life-changing, they rolled it out at CES, and I was like, how did I not know this was happening? This is amazing. So if you have a Delta Sky Miles, which is free to sign up for, if you're logged in Sky Miles, you can watch YouTube with absolutely no interruptions on your flight. I just can't wait. All right. Let's roll while we still have daylight, because that's what we're working with today. So, you know, it is like the land of all of the sun. So we're here. All right. Law nerds, let's go to court. Hear ye, hear ye.
Bring the jury.
I'm teasing. There's no jury. Bring the jury of the law nerds. The internet jury of the law nerds. You know, docket number 214. We are ready to roll. Hear ye, hear ye.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable
I love it so much.
Justice of the Norfolk Superior Court in for the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
I love it so much.
Take yourself into office, put away.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Everybody's going to say hi.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. David Dinetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right.
So what do we know?
So
We know
to
that today
start-
we're going to get argument probably from Alan Jackson because he's the one who filed the motion. We're not going to see Mr. Alessi and his delicious wordplay because I just love Alessi's. The Alessi's turn of phrase is fantastic, but we're not going to hear from Alessi today, not present in court. He's there for some of the other things, and I think that's great, but we're not going to hear Alessi. You guys are saying court is quiet. All right, no worries. We can bump that up a little bit and make sure it is not too loud, and we've got subtitles. So, wait, YouTube subtitles just said Alan Jackson from the streets. Yes, also yes. Also yes. AJ from the block. He's like, I'm ready for it. All right, let's make sure this isn't too loud, but give you a little bit boost on the court sound.
I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions.
Oh, well, hey there. We're starting. Hold on. I need to make sure that I'm in my notes. We're going to start with the court. It sounds like giving an order on last week's motion. This motion is the one that requested a hearing. The court said, I don't need a hearing. So the reason the court is reading it that way, for anyone who's going to be like, I hate this judge, she's XYZ, whatever, that's the title that the Commonwealth gave the motion. Is it a shady title? Yes. Is that the court? No. The Commonwealth titled the motion that, so the court has to keep reading it because that is what the Commonwealth titled it. The Commonwealth's motion was to exclude the debunked opinions. That's the court, not the court. That's the Commonwealth reading what the court said. That's not the court. Emily, if you get it wrong, it's going to fire. It's not the judge being shady. That's the Commonwealth with the shady title.
So after review of the...
Your Honor, you sound like you were out at Jelly Roll all night and are like, and now the lawyers have to fight. Emily in the chat said, thank you for clarifying that. I got frustrated. I understand. And if you don't see the motion in front of you, it's hard to know if the court is the one saying debunked opinions. It's not the court saying that they're debunked. It is the court reading out what the Commonwealth wrote. And that one's not on the judge. When it's on the judge, I'll tell you. When it's not on the judge, I'll also tell you. But I understand when you have feelings about the judge, everything just goes into that container, right?
The pleadings, it's clear to me that the issues that
Their opinion.
give rise to the dispute do not invoke the gatekeeper function of the court. To me, it's rather a difference of opinions that need to...
Are you ruling from the bench right now? What? I am not still intoxicated from last evening. I streamed in the afternoon for reasons. But are you just giving rulings right now all from up in the bench? Ma'am. Hi. Where have you been? What? Ma'am? Ma'am. Can we do this? Can we just do this more often? It is for the jury to resolve. Law nerds! I am pleasantly surprised. Well, look at that. We're just going to back up. Your Honor, I'm going to let you finish. I just was shocked and I had to pause. The judge is going to rule right now. Let's go.
Jackson.
Good morning, Your Honor. David Dinetti for Karen
I'm backing
Reed.
all the way up.
Good morning, Mr. Yannetti.
I did it.
Good morning, Ms. Reed.
I did it all.
All right. So to start...
Just okay.
I'm going to start with the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So after review of the pleadings, it's clear to me that the issues that
You're right, Your Honor. This
give
is
rise to the dispute
absolutely
do
correct,
not
yes.
invoke the gatekeeper function of
Correct.
the court.
Correct.
To me, it's
Correct.
rather a difference of opinions that need to be resolved by the jury.
Correct.
So I'm denying your motion. I'm not going to exclude the evidence. All right. So then I think what I'd like to move to.
That's what I hoped would happen. That's honestly what I hoped would happen. That I think is the right ruling. This was a motion that we covered last week. This is the appropriate ruling, I think. I think this is for the jury. That it is not that the experts aren't qualified. It's not that they're relying on an unreliable methodology, like throwing a cell phone around to see what happens. It's that they have a difference of opinion, and the difference of opinion is what it is. But that's for the jury. 10 out of 10.
10
out of 10.
Is the defendant's motion to recover expert-related expenses from the Commonwealth. I did get a response from the Commonwealth on this, so I need to hear, Mr. Jackson, what it is you're asking me to do and why.
I want to hear all the tea.
The court did receive the addendum filing the court asked for as well, correct?
No, because I've been waiting for it and I do not have it, and I checked as recently as 5 o'clock yesterday and this morning.
I'll get it.
Okay. Do you have an extra coffee for me? Because I don't.
Do you have an extra coffee for me? Oh, copy.
When did she send it?
I also need extra coffee.
Yesterday, I think I was on the plane.
Margaret checked for me yesterday.
He's like, I think I was on a plane.
Can you come
Probably
here for
on
1
Delta.
second, please?
Lawyers, I heard extra coffee too.
Who was
Lawyers,
she?
let's
Did
go.
she send it to all the clerks like she's supposed to, or just Mr. McDermott?
I think she sent it to everybody. Her normal filing.
I know, everybody's like, we need coffee.
No, Judge reminds me, I did get something else. It wasn't this.
It was from the Commonwealth, so I've been waiting for this, so I need a
That
minute
was
to
sent
read
at
it.
12:57 p.m. yesterday.
I did not get it.
No.
We're just waiting to see what's going on with their reply.
More
She'll
importantly,
probably
the
let them do
Commonwealth
it
got
orally.
right?
Yes, that's my copy I handed to
So
Colin.
she's
thank
just
you.
going to let them do it. Okay, are we gonna, do I need to zoom? I'm worried to zoom because I'm on travel internet. So I'm hesitant, but also. Emily, also what? Well, there are times that it's appropriate to zoom. Let's see if we can. We'll just zoom a little bit. I'm sorry, Miss Jackson. Wait, no. Wrong, Emily, wrong. Last night, though, in their montage, there's like a 90s hip-hop montage. Got it yesterday. Oh, geez, we're all just gonna stand and wait, huh? All right, well, zoomy zoom. All I wanna do is zoom. All I wanna do is zoom. Okay, somebody said something. Oh, I'm gonna push too close to the sun on travel Wi-Fi. All right, we're gonna let it roll. We gotta be close. Are we ready? Are we ready?
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of.
I mean, if it wasn't there at some point, it was erased. That's just the way it is. Some of you are asking for a little more volume. Let's see if we can give it just a little bit more without destroying all of our ears.
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what our concerns are in my oral statement.
All right. I'll hear you.
May I?
Yes.
The court started by
There we
asking what is it that the defense is asking for. Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass.
And we've seen that happen in other cases. In other cases where there is an issue that is charged to one side or the other, then that side can have to pay for whatever the issue is and to remedy that situation.
700, it's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases back from going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano
The court's like, yes, I'm aware. Can we...
in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, or held was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation.
Okay.
And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is, and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward, really.
It's
I mean, it's just
obvious
a series
that they are
of videos
relevant
at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before.
If the Commonwealth
the first
argues,
trial.
and y'all,
I'm
not asking for spoilers.
Do you have a date?
I'm not asking for spoilers, but if we see the Commonwealth being like, well, is a recording physical? I will start yelling. I will start yelling. But yes, everything needs to be preserved. It's criminal. There's no, obviously, it needs to be preserved. And you shouldn't have to ask for, just my 2 cents, you don't have to ask for a preservation order because there are also obligations of the Commonwealth. Yes, some jurisdictions are going to cause you to go the extra step as a CYA, but you shouldn't have to ask for evidence to be preserved. If it's evidence, it must be preserved.
Have any chronology for me?
I don't. I can certainly provide those, but it's been...
I'd like that. I mean, that would be...
It should be on your docket, Your Honor.
I'll be happy to do that. It's in discovery.
It's you have the case file, Your Honor. I gave you the date. 2/2/22. Can you give that to us? No. It's in your file. Flip back.
Discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had
that's
video
not their
footage.
job.
We didn't know how many cameras there were. But we didn't get anything from the Commonwealth. And I'll address that in particular.
I'm curious about the timing.
Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons, and I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for
it's a
it
criminal case
to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case.
I'm going to also note they have to turn over evidence that's not exculpatory as well. Like the inculpatory evidence also has to be turned over, but like especially the exculpatory evidence, like the inculpatory evidence is like, well, you know, dude did it. But the reason that the rules are so specific about the exculpatory evidence is because there is case law where the exculpatory evidence just magically never got turned over. The prosecutor's like, I didn't think it was exculpatory. And then the courts were like, yeah, you're not the judge of that. I think for most prosecutors, the best bet and the tack that I prefer to see people take is we will turn it over unless it's like attorney work product, because that's just attorney notes don't get turned over. We will turn over everything. And then if it's something that shouldn't be admissible because it is notes or a report that's not admissible, then you just argue that it is not admissible at trial. You don't not turn it over. Like, that's not the option. You turn it all over and then you lawyer. That's how the process works. Turn it over, then lawyer. That's all. That's it. That's how that works. No hide the ball, nothing shocking, just turn it all over and go from there.
The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D.
Oh God, we've done
Commonwealth's Brady obligation is
we've done so much with the rules of professional conduct. We're going to have to do a full rules of professional conduct breakdown. We're all just going to get CLE credit for it. It's going to be perfect. We'll just have to do a day talking about the attorney rules of ethics. This is how I saw the attorney rules of ethics. I looked at the attorney rules of ethics and went, that is the floor. If I just go well above that, we're not going to have any problems. We'll just take that as like the minimum requirement and just go up from there. And then we don't have any problems. Again, as a prosecutor, you're not playing chess. You're just turning it all over. Keeps it real simple. Just keep it easy, people.
Self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, within their own time frame, to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video.
Oh, we're all well aware of this video.
And heavily referenced at the first trial.
Yep.
That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the Sallyport. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022.
So
another one of those videos was the inverted video that has now seen some fame. that the Commonwealth tried to sell to the jury as a true and correct copy.
Excuse me, AJ. If you're going to talk about internet fame without mentioning the law nerds, like a new standard has now been set by Bloodworth. So I'm just saying, like, if we're going to talk about the inverted video because I was inverted, then we're also going to have to just reference the law nerds, sir.
Of a video within the Sally Port, and we got that one after the trial started, in the middle of trial.
Which is also fucking wild.
So why were we getting videos from January 29th, 2022, 2.5 years later?
This is a good question.
And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions.
I am not always with him on altered or manipulated, but I understand his argument. I don't think we have enough information to know if they were altered or manipulated, and that's the problem. If they don't have the metadata, they don't know if it was altered or manipulated. I don't know if it was altered or manipulated. But if you don't have the metadata, you can't prove or disprove it, so they're going to make the argument this was altered. Why is this relevant time period missing? If it's motion activated, shit should be moving, therefore it should be activated.
Asking that question, and while we're pondering that question,
it's a good question.
A couple of days ago, we're getting yet more videos.
That's wild.
Scraps, piecemeal. We got another Sally Port video just a few days ago. This one showing the Lexus backing into the Sally Port from some exterior camera, and that also is exculpatory evidence.
How are you just getting video now of the Lexus backing in to the port? Girl, we knew about some of the video they had just gotten in their motion because they talked about the video with Higgins on the phone, but this is ridiculous. This should not happen. And the condition of the Lexus is critical to the case. And somebody can try to convince me. I don't know if you're going to ever succeed, because we know from Proctor's insane text messages that Proctor saw Karen Reed as the main suspect from like the second he got the call about the case. That's hyperbolic, but it was within the same like 12 hours of the death of John O'Keefe that Proctor knew, that's not the right word, believed that Karen Reed was the only suspect and also had a lot of other strong opinions about her. So he thought that Karen Reed was the main suspect. So you're not going to convince me that nobody appreciated the value of the car, because the car is what they were considering a murder weapon. So you're not going to convince me that they went, oh, well, we just didn't see it as relevant evidence. There are cases where that can happen. This is not that fact pattern. You know it's relevant. You know that it is something you need to preserve. I'm very interested to hear how the Commonwealth responds to all of this, but you know you need to preserve it. And the fact that it's now getting turned over, going on 3 years later, means someone saved it. Someone saved the video. So where the fuck is it, and why hasn't it been turned over? You're not just finding it now on the DVR, because it had to be preserved within 30 days. So where the fuck is it? You know who needs to ask these questions?
The FBI!
Where are you?
The FBI!
Where are we at with that investigation? Because how the fuck does this happen?
Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit.
That's strong words, Brennan.
A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured.
Well, they probably put it somewhere.
So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source. Had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out. You can have your expert come out, meet us at Canton. We'll provide the DVR. You can have him look at it. He can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe?
I've got questions
That it
about
was
that.
on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have.
They should
This
have.
has been the center of a storm that surrounded this case from the jump. And to claim otherwise,
One would think.
it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also.
Well, did you
How
tell
am
them
I
not to
supposed
touch it?
Know what is or isn't
I've
on
got
the
questions.
Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was,
boy.
Mr. Brennan, do me a favor if we're going to come out there, just don't have anybody download it in advance.
That
Let's
makes
do
sense.
It all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that.
And that makes sense. But then you have
So
to
based on this
say,
history of getting these
is there anything to download?
small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more
wild.
snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins
We see what you do there,
standing
bytes
out in front of Canton
versus
Police Department
bytes.
in the parking lot in the freezing cold at 1:35 in the morning on January 29th. On his
I was snarking. I was snarking about bits and bytes. I love that closed captioning got it right, but I didn't want to miss the discussion of Higgins. For those of you that watched this trial the first time, Higgins was strongly denying phone calls that phone records showed. So when Higgins was on the phone matters. It might not be that part might not be exculpatory. We can have a conversation about that. I need more facts. That might just be impeachment. But the Lexus and the state of the Lexus is a whole different conversation than Higgins. So I want to hear more about Higgins on the phone because, again, this might be impeachment, not exculpatory. But, again, they're going to make the argument. I want to hear about it.
Bits and bytes from that DVR, and one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone.
Michael,
To
that's
punctuate
amazing.
the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular,
Talked about Higgins.
spoke with Mr. Higgins about this issue. It was
he
raised
was-
at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination,
As a butt dial.
admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury,
Right.
when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady evidence,
The
and it was
court
withheld in
might
its
say it's
entirety
impeaching.
during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then said.
The issue with the evidence with the Lexus vis-a-vis Higgins is going to be different, but it is strong impeachment evidence. If it is Brady evidence, that is a different conversation, but it is at minimum in very strong impeachment evidence. So I think they impeached Higgins quite a lot, but impeaching somebody with video is a different thing. Oh, you never made a call that night. Oh, everything was a butt dial. Oh, the mysterious, like you butt dialed your buddy who was bootying down with his wife, and then he butt answered the butt dial that you butt dialed, and then everybody's phones go missing. That's weird. So having him on video on the phone when he said I wasn't making any phone calls is important. And also, this dude was drunk. Like, dude had been throwing back whiskey all night and then drove, apparently in the snow. I don't know. Was it proven that there was snow? Drove to Canton PD and was like doing shit at Canton PD. What are you doing at 1:30 in the morning, drunk at the police department, on the phone? Weird. So they're going to argue it's exculpatory. It's at minimum impeaching. Should have been turned over. The video of the car, I have much stronger feelings about, but we don't have enough information yet.
Say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on.
Agreed.
Just give us the raw footage. We'll send an expert.
They want to raw dog it. Do it, Brennan.
So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms.
He paints a
Reed's
picture
expense.
with his words.
She's writing the check
Yeah,
for
we know.
all of this.
The court knows this.
And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days.
Which they would have known 3 years ago.
How could that possibly be? So the expert calls me. Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech expert. Yeah, it's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR.
Somebody saved
who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that, and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage. You get no log. This was a complete and utter waste of time.
Did anyone sing the log song? It's log. It's log.
According to the Commonwealth, that system, as I said,
It's not gonna
overwrites
help
every
today. He's
30
too
days.
pissed.
So by February 28th, I counted them. By
Somebody
February
had to have
28th,
saved it.
2022, every single frame of that footage should be gone.
So where is it coming from now?
So how did we get the inverted video in April of 2024? How
Someone
did we
saved
get
it.
the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years.
And that's not okay.
Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd of Ms. Reed's money, and fly an expert out to Canton for absolutely no reason. Zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it.
Yeah, why weren't they
But within
told?
10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen
Or at
Reed
least the last
is the
30
one having
days.
to foot the bill for what turned out to be just a snipe hunt.
Where's the footage then?
It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account.
I'm sorry.
Not on the DVR system.
What?
Not in the official data bank.
What?
Which is supposed to be stored, but on some iCloud account.
What?
And we're finding out about this in 2025.
What?
It's outrageous. What it is this.
What? No, we're backing up. There was an entire download in an iCloud account. What? Oh, we're just now finding this out? I'm backing up. We need to listen again. I am not processing.
It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making.
Tell me.
The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer.
So here's the timeline that I am picking up. That the defense sent their expert out there. The expert got out there and they're like, there's no original footage on the DVR. That is the system that runs all the cameras. The logs are gone. There's no original footage on the DVR. And then they asked all the questions. Their expert is like, did you save it somewhere? And we read the defense motion. If accurate, which we don't have reason to believe it's not, the defense said, our expert said, did somebody download it somewhere? And then, no. Did somebody do this somewhere? No. Okay, well, where is it? And they're like, IDK. And then after the defense expert leaves, Brennan goes to the police and is like, hey, so where is the footage? And then they find something? What? Okay. What?
And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official
evidence
data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025.
No.
It's outrageous.
That is outrageous.
What it is this entire situation surrounding this DVR and the Commonwealth's.
The only way this will not outrage me is if the defense was given that entire footage on a thumb drive 3 years ago. Like, the only way I'm going to be unmad about that is if it was all turned over. If it wasn't all turned over, pissed immediately.
Maintenance
Immediately
of that DVR
pissed.
and the footage on it is a complete dumpster fire, and Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense.
That's wild.
And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill.
I mean, when they fuck
And
up,
the reason they had
pay.
to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order.
Yeah, the Supreme Court said you break it, you bought it.
Absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
I am
Thank you very much.
very interested to hear the response from the Commonwealth here. So, new information that we learned from the defense before we get into the Commonwealth, because just, I don't think I have bra on this soundboard yet. The new information is that there is additional video that since the defense filed this motion has been turned over. And there is new information that an officer told the Commonwealth in 2025, oh yeah, it was all downloaded into an iCloud account. What? What? And for all of you asking, and I know you're going to ask, and for anyone with spoilers in the chat, you're going to get yeeted, just so you know. The law nerds wait, and we appreciate it. But if you want to come in and spoil, you yeet. And thank you to the mods for that. But this is not a motion today to dismiss. This is not the conversation for today. There is going to be a defense motion to dismiss. We are going to get into the defense motion to dismiss when they file it. This is not what they are doing today. So we are focused on today's question today. Are there things here that are a problem? Yes. Are those problems going to be addressed more fully with more information than we have today? Yes. Today is to decide who bears the cost. And I'm very curious to what the Commonwealth says that they told the defense. Because if they told the defense, this no longer exists on the DVR and the defense flew out anyway, that is a different situation than the defense being told, hey, yeah, come and download it. Those are different situations. All right, let's get to what the Commonwealth has to say, because I'm all ears. I'm real curious about how the fuck this all went down. Like, what the hell is happening?
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted.
That's what they said.
Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing.
Are you saying don't get it flipped? Is your argument really don't get it twisted? What?
To stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys.
That's not my siren. I find it embarrassing, Brennan. Embarrassing? Who else files the motion for costs? You want the attorney to file? I mean, the attorney can file the motion for costs. But the expert are like, these are my costs. Sir, did you watch the first trial? Sir, have you read the text messages? I need to know your threshold for embarrassing, Brennan.
Courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense.
Yeah, you probably do.
I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth.
Well,
so now I must stand before you, and I must tell you what happened.
A lie unchecked becomes the truth is a great saying. I don't know if that's what's happening here, Brennan, but a lie unchecked. It is a great quote. But he's like, I do not want to disclose these conversations. What did you tell the defense?
I did this case in September, and I began to look at discovery. I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the...
Are you telling me that the motion to preserve in February wasn't a motion to preserve, or are you going to argue that physical evidence does not encompass digital evidence? where we
government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to the...
If you have to go to, in my 30 years, I've never seen, you don't have much else to argue, do you?
...to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or
I said,
DVR
sorry, Ms.
of the Canton
Jackson.
Police Department. I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort...
If you think that they are not entitled to do an evidentiary download with all the metadata, then you go to court and you do motions over it. But if you had just turned over all the video with the metadata attached, I imagine we wouldn't be here. That's me speculating in my 20 years. So let my 20 years speculate. And if the defense is asking for something that you think is outside of their purview, make a motion and argue it in court. You don't get to just decide that it's not there anymore, but we are so far away from it's not there anymore, like so far away from it's not there anymore. Also, metadata in digital evidence matters. The logs of who accessed the DVR matters. And so if it's gone, then there should be consequences for that. Ugh.
Effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial. I wanted to do what I could to accommodate them.
I'm waiting for him to be like, I don't know how they do it in LA, but here in Massachusetts, like I'm just waiting for the shade for the like, you're out of state, which is why I can't even watch what's going on in Los Angeles right now, because the LA attorney who I like, who has just gone wild, is just like, here in California, because the other attorney's from New York, here in California, it's like all of the regional shade. It's like, I don't know what they do in LA. Well, ask for everything is one of the things. I don't know how they do it in LA. Sir, yeah. And for any of you that are newer here, hi, welcome. Am I particularly feisty today? No. When the lawyers get wild, there are days that I just lose my mind with it because really I'm here to give you commentary on what the lawyers are doing. And so the Brennan standing up here and being like, this is embarrassing, and in my 30 years, no one's asked for this. In your 30 years, have you seen evidence not turned over until after the first trial was done? What about that? How about
without
that?
any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth.
Giving video to the defense is not unprecedented or novel. Just so we're clear. And if the Commonwealth had just preserved it with metadata, the way you do a forensic phone extraction, then the defense wouldn't need to ask for their expert to go do an extraction because the extraction would have been done the way you do with phones. Why is that weird?
Will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense
That it wasn't
attorney,
there.
that almost 3 years later, the video may not be on the NVR.
Okay, real
I had
concern.
the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence.
Good.
And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing.
That's interesting.
That they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did,
I know a lot of y'all don't like Brennan.
The information had...
I get it. I get it. Here's the point that I am curious more about. That if Brennan said to Jackson, I am not sure it is there, I am not confident it is there, I do not think it exists, and Jackson said, we want our person to be the one to check for it and to verify that it doesn't exist, that's different than if he said, yeah, sure, we're sure that there's something there for you to download. The kind of fine point between that is going to be interesting to see. I am not saying that what the Commonwealth is doing is right. Please do not confuse it. The fact that this video is trickling out is a huge problem for me. But what was said to Jackson matters. And if what was said is, we don't think this is here, but if you want to come check, we'll let you check, is different than, yes, come download it, it's here. And this is going to come down to really a parsing of that. So I want to hear more about this. And I'm curious to hear more about this. But we're going to end up with Jackson being like, they told us to come download it, and Brennan being like, we said we weren't sure it was there, but you can come look if you want to, and you don't want us to check it. If you don't trust us, then we're not paying for that. And I can see why the defense would be like, well, I don't think we have any trust at this point. We just need to see. This is going to be interesting. Oh, and yes, if you guys can hear, I do have the window open, so if there is some noise wandering in, I get it.
Been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July.
Backup hard drive? Backup hard drive? Do they have a full copy of the backup hard drive? Backup hard drive. Did anyone give it to the defense? I'm curious. I'm curious.
July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. One reason
I'm backing that up. I need to hear more.
And I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason.
I need to hear that again. Are you saying that in July 2024 is when they got information that there was a backup hard drive? Because that's still a fucking problem. That's after. What? I need to hear this again.
Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they...
If materials were there in July 2024, why weren't they there in December? If they're already there, why aren't they there in December when they go out? Where did they go? Between July 2024 and December 2024, where did the video go? Do not tell me it was killed by the radio star. Law nerds, I see you. I see you I see you.
Wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras. I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that...
Excuse me? The video should have been provided to the defense like 2 fucking years ago. Your Honor, it's just my obligation to provide them the video before trial, though. But I went above and beyond. Do not. But Your Honor, I could have just done that. That's the minimum. We're well beyond the minimum. We're well beyond the minimum at this point. You're after a trial. Oh my God.
That if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them. Because they had already been part of the process, I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information would...
Why couldn't this have been done when the defense expert was there? Why did all this information get miraculously discovered after the defense expert left? Why couldn't this have been done same day? What? Yo, it's not on the DVR? Okay, is it on another hard drive? Look, where is it then? What can they copy? But no, it gets discovered after the defense expert leaves. Seriously.
Whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense
It still
waited
hasn't been
almost
turned
3
over.
years. The defense was very clear.
It still hasn't been turned over.
About my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause.
Parlay.
The case they cite, Commonwealth v. Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves,
sir,
and changes and retools.
Sir,
what we have now,
sir, from 2022 to 2025, you didn't turn over the information, and then everybody's like, oh, there that is. No. I think it should... No, I'm going to let Jackson watch all the video and then make the motion to dismiss, because this is going to bump the motion to dismiss, because he's going to have to watch all that video to argue what's potentially Brady. And if it's Brady, then we have different issues. But at a minimum, it's a massive discovery violation. I think it's probably more than that, but it's a massive discovery violation, and then you don't get to use any video. But the mysterious retired person is like, oh, it was on a hard drive somewhere. The fuck? Oh, as the case evolved, you had to download this within 30 days of when the crime happened. What did you use to prove your case? Did nobody want to... oh, my bad. Nobody wanted to check. Silly me.
Now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional
That's the question for today.
In an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations, or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court
That's
today.
true.
The motion before the court today is to
We
attempt
agree
to
on
recover
that.
costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Any quick response,
Yes.
Mr. Jackson?
Very briefly.
Yeah, I
with the
bet.
court's permission. By the way, it is a Brady case. There's no question that the data on those,
We're not there yet, though. I get
on those
that.
videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case, don't worry about it, let's just sweep this under the carpet like we've done everything else. It's, you know, there's nothing to see here. That's not true. It's a Brady case
Jackson's
because
so
the
mad.
information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed.
How is there
That's
still
why I
more?
cited,
Brian Higgins' part?
that's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well.
We haven't seen it yet,
The
though.
inverted
so-
video part is also Brady, which we got in the middle of trial.
Higgins, the inverted video, video of the car backing up could all be different. We're not on that motion today. I need more information.
Mr. Brennan says, basically, his
But
argument is, you know,
Brady's
it's
gonna
not a
be
motion
argued.
because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all.
Just do your
It's about
fucking
the
job
defense
and we're
of the
good.
Commonwealth. It's about Ms. Reed and the Commonwealth.
It's personal to her.
But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously
Doesn't matter.
for the last 2.5, 3
Yeah, it
years.
doesn't matter.
To me.
'Cause
This
it
is
doesn't
not
matter.
personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this
Right.
case
It's an
not
entity.
to represent Mr. Brennan, but to represent the Commonwealth.
It's
and
an entity.
all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility.
That's true.
As lead counsel for the Commonwealth.
He didn't break it. He's still got to fix it.
He indicates that when
He chose, by the way,
found
to do
out
that.
we wanted to come look at the DVR, and we had absolutely no right to look at that DVR. This was just a courtesy, etc. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right? So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean? Let's do it the transparent way.
Jackson,
have
you're...
everybody come, bring their experts, whoever they might.
What Jackson has not said yet is that he has not disputed, this might be a problem, he has not yet disputed that Brennan said, I'm not sure if it's there or not. He's not disputed that point yet. And if Brennan said it may not be there, that's going to matter for this part of the hearing. We are not at discovery issues. We are not yet at their motion to dismiss. We are at who pays. He has not said, Brennan never said that. And that, I'm curious where he goes with that.
Let's download the stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart. Until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can come look all you want to. The bucket's empty.
Oh boy.
I have no idea about this iCloud account, or who owns the iCloud account, why this data on January 29th was moved from
Why this
the
data?
DVR to the iCloud account. Mr. Brennan did say Do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court.
Right. That's
And
fair.
I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person.
But they need to get
That
this
may be an
motion done
option
first.
that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process.
Right.
But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady.
Discovery.
It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court. Blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one totally, I wasn't the one
That did happen.
You can't, I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish
big
a
question
single
of the chain of custody.
for
It's a
those
huge
videos,
issue.
and we still don't have it. So
It shouldn't come in.
Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was the
court's not going to like that.
We were led
argument
in a circular runaround, and it was ultimately at her cost, and that's what's
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you
That's
saying
the
that part's
question.
not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So
He's not
yes,
answering that question
I was
directly.
concerned, but who cares? Well, that's
That-
no legal moment. What I thought
that
when
matters
Mr.
to the
Brennan and I
court.
discussed 3 years after the fact, when the Commonwealth has a self-executing
That's
obligation
gonna matter.
to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand?
But
Is that in the file?
if he knew, and whether it feels like bullshit or not, if he knew that everybody said it's likely that it's not there, then sending an expert might not have been misleading. It might have been a strategic choice. So he talked very much around that the attorneys all seemed to agree that it wasn't there. And Jackson never said, no, Brennan didn't say that to me. No, the Commonwealth didn't say that to me. If the Commonwealth said, we're not sure this information still exists on the DVR, that is a different question because it goes to the cost. The other issues, the discovery issues, the Brady issues, all those other issues are going to be dealt with in different motions. This matters to the money they chose to spend. Were they misled, or did they choose to spend it to try to find the information on the DVR? I also want to know, if they were already out there, why they couldn't just download the hard drive. That is a huge question to me as well.
And where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February
214,
2nd.
docket
after a
214. I'm being facetious.
Here?
Wherever the arraignment was, Mr. Yannetti.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, When was that filed, and did Mr. Brennan
No,
actually...
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
I thought it was part of the file.
I can't say with certainty, but I believe that it
Why
may
is it
have
not
been
part of the
submitted
file?
as an exhibit to a previous motion, probably early on in this case.
Okay, I just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court.
I may...
They should have attached it. They should have attached it. I think because the court gets caught up on these things, it should have been preserved either way. They should have attached the order either way, but it should have been preserved with or without the order.
may have filed it as an exhibit.
Attachment, but it was never
not-
any...
Right. There was, I don't mean to cut off the court, Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court. That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed. I need to see that.
By the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamp.
Yes, we've heard that.
My point is, even if that weren't the case,
It's still their
and it is
obligation.
The case, the obligation is self-executing. That's what Justice.
I don't disagree with him about
talking
that.
When he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve
evidence,
exculpatory information, and provide that information to the defense. They didn't do that, and they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now,
Brennan's actual
suggested
knowledge
that
isn't
that
relevant.
information existed, the DVR existed.
I should explain that.
Sorry.
Sorry, Chad. I should explain that. Brennan's personal knowledge is not relevant, and I say that because he is part of the prosecutorial team. So whatever Lally knew, the law says Brennan knows. Whether he actually knows or he, like Scotty, doesn't know, it doesn't matter. It is under the law, the team knows. If one person knows, everybody knows. That is the obligation. That is well known. Everyone knows that that is the obligation and that is the job. So if law enforcement knows and the DAs actually do not know, never seen it before, never told about it, it doesn't matter. It's presumed that they know. Now, the courts will say, I find that the prosecutor did not know this, but it was the obligation to turn it over, even though they didn't have knowledge. They didn't do anything nefarious, but it had to be turned over. Those are bigger conversations. But it doesn't matter if Brennan didn't know, if Lally didn't know, if Scotty didn't know. If law enforcement downloaded it and had it, then it's like the prosecution knows and didn't turn it over. So I understand his frustration here because it's wild to me that video just keeps like miraculously popping up. It's like, oh, where did we find that? It's evidence in a case.
The video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll submit.
All right. Mr. Brennan, I have just a couple of questions.
Yeah, I got questions too.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded. That has been searched.
Commonly is overridden every 30 days. Like
has been overwritten.
Statewide police departments.
Yes, Your Honor. And that has been overwritten.
Okay.
And there is no information on that.
Okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures.
How does evidence know it exists then? How does evidence know it exists then? How? We're just holding on to this video. We're not, I mean, is that why there's no chain of custody? Because, like, some dude just did it and was like, yeah, I'm just going to hold on to that. What is happening? Sometimes you just save shit. I have so many questions.
All of the video, it's when he would make a copy. And it seems in this case there were select copies made.
Select?
It doesn't seem that there was... Select copies made? Can you back up? Can you back up and explain to me how evidence in a case is select copies? At least Brennan seems to be giving us the accurate recitation of what he has learned happen. But also, select? I'm going to back up. I'm going to stop interrupting him. Okay. So the DVR has been overwritten. Some dude downloaded some things that they chose and selected. What?
Affidavit.
So there's two different
So I backed
systems.
up.
One's called the DVR, NVR. That's the
I just need to
actual
hear this
system
again.
that keeps all the footage that's recorded.
That
That has been
that
searched.
commonly is overridden every
Yes.
30 days. Like
Has been overwritten.
statewide police departments.
Yes, Your Honor. And that has been overwritten.
Okay.
And there is no information on that.
Okay.
That we figured.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists?
So I totally lied. Select copies made, and I don't think, is what he's saying, anyone made a full copy of all of the video from that night. What the fuck? What? I can't go code red visually, but I'm at code red vibes with all of you. I'm at code red vibes. So we can go based on vibes. I can't change my lights because I'm not here. Or I don't, sun. If the outside turned code red, I'd actually be terrified and have to stop stream. We've had bigger problems, but I'm in code red vibes. Miguelina, we don't need to send it out to the app, but I'm in code red vibes. We'll just mark it down below. I'm in code red vibes because here's what I think we've just learned. Some dude, now retired, saved some select videos, but all of them weren't saved, and everything's been overwritten. So like you get what you get and you don't get upset, which is not how discovery works in a criminal case. Not how it should work in a civil case, but they throw that out there differently. Chat, we are going code red. For those of you that are new here, if you have any flash sensitivity, code red is a little flashy. It ends when the music stops, but we're going to code red in vibes. In 3, 2, 1. Because seriously, what the fuck? I feel like Brennan is trying to give an explanation of what's happening. It's not a good explanation, but I do think he is telling us what happened. It's not good what happened, though. What happened is not good. Okay, Brennan, let's keep going. Let's just keep going. Let's see what else we learn.
His hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and defense, and he would put on that separate file.
Those are not code red. I feel like IRL, they went code red, and all of the sirens went code red with us because vibes. But that's not here. The sirens also went code red for all of it. It's probably code 3, but you know, same.
I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2000.
I need to hear what you're saying. You don't think it's going to be an exhaustive copy? How have you not checked this yet? Oh, he said he hasn't checked this yet because he was waiting for Jackson to decide how they wanted to copy it, which at some point, can't you just say, I don't know. Can't you just say, look, we're going to make a forensic duplicate and I'm going to check it? Because now he's like, I don't even know what's there.
Made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and the defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he's provided in this case.
Select videos?
Before it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first place.
So let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer at the defendant's request.
They're going to need that for their. They're going to need
They want to
that
have somebody there. I'm receptive,
for their motion to
but we're ready
dismiss.
to do it now.
All right, so
Oh
I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further in
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanctions or to dismiss, or whatever the remedy is, because they think they've been aggrieved, that would be a different motion. This motion is they're trying to get the court, or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known
There will be a separate
the defense
motion.
was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's motions and requests. And
Well, that's not the motion they made.
But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
We'll get started on that immediately.
All right.
Oh my goodness.
So
What are they looking at on their
let's
computer?
move on
Hold
to
on.
the
What in the world is on that laptop? Emily, you can't wrong answers only. It's a murder trial. Don't. Just keep moving. But I'm always so interested when we see the back of what everybody's got on their laptop screens in court. So the court's moving on. Let me make a note real quick that the court is taking that under advisement. Okay. Let's see what the court moves on to, but there's a lot of new information that we just
Commonwealth's
learned.
motion for clarification regarding the search warrant, or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the
So we have moved on to a separate motion. We have moved on to the court asking them about the Commonwealth's motion for clarification regarding a search warrant regarding the defendant's phone.
Commonwealth to search for data that's outlined in what's known as addendum or attached as addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privileged information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report.
Oh, no, you didn't get all the data?
When we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information.
Oh my God, when you don't get the data, it's so frustrating. It's so hard to prove your case when you're not given all the information, isn't it? Wow. It must be real frustrating for you. Brennan. Also, what was Lally doing? Like, how is this just coming up now? This we heard about during trial. In trial, we learned that there were text messages between Yannetti and Karen Reed on her phone, and so a taint team went through some of those downloads and decided what would be turned over or not from the U.S. Attorney's Office to make sure that the information between Karen Reed and her attorneys was taken out and not turned over. And Brennan's like, well, the defense got the full forensic download, and we didn't. Wow. That must be hard for you.
A PDF.
You only got a PDF? No metadata. No metadata, just a PDF. The horror. But also, how is this just coming up now?
I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect for the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so
of course you don't want delay.
The court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st trial, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in mind.
I bet there's an opposition.
Really The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, it was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search
Right,
warrant.
so that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court
Within
said, squarely within
the search
those
warrant?
parameters. January 28th at 9:30 p.m. until January 29th at 5:30 p.m.
Well, that's eminently
Otherwise,
reasonable.
I don't disagree that pursuant to the search warrant, he can get the I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
Look at them all getting
Mr. Brennan
along.
did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right.
Look how reasonable we all can be.
So the motion regarding, just want to get, Commonwealth's motion for.
All right, we are moving on to another discovery motion. For those of you that are like, literally what just happened, I know, right? Brennan, the special prosecutor for the Commonwealth, said, hey, there is a digital forensic download of the defendant's phone. There is a search warrant that entitles us to not just a PDF, but the full forensic download in these areas. I need the court, because the AG's office was going through that to make sure that no privileged communications between the defendant and her lawyer were turned over to the Commonwealth, which is appropriate. Your Honor, hey, they didn't turn over these other things. These other things fall under the search warrant. We want that information turned over. And what the court said is, you're not required to come to us with this information. This is between you and the AG's office. If it's within the parameters of the search warrant and the privileged communications are taken out, then yes, you don't need my permission. Yes, you are entitled to it. For point of clarification, now we're moving forward. But I can't believe this wasn't addressed before the first trial. I mean, maybe I should, but how? I don't understand the rush to prosecute this case when it seems even the Commonwealth didn't have the full information and we're just going forward. You don't prosecute just on, it seems fine. Look, what? You didn't have to rush this. Wait till you have the information. For the Commonwealth to be saying there's still info we don't have is bananas to me.
Reciprocal discovery pertaining to employees of
Another
ARCCA.
motion.
And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information
no.
you have? Or how do you want to do this?
Whatever the court's most comfortable with.
Tell us.
An open court or sidebar.
We want to know.
I'd prefer to find out what's going on over in federal court at
We wanna know.
sidebar first.
Boo. That's the right call, but also boo. The court's not wrong. I just don't like that ruling. The court is correct. They're asking what's going on in federal court, subject to a federal grand jury. That is not something that should be put out publicly if there's still an ongoing federal grand jury. I just don't like it. It's not wrong. Give me the tea. Every single time we cover this case, the question is what's happening in federal court. We all want to know. So they're going to sidebar. I'm going to Zoom while they are at sidebar. It is going to test all of the strength of the internet while I am traveling. This looks like a kind of a long sidebar, actually. So I'm going to try to Zoom as best I can, because I am curious about the reciprocal discovery with regard to the ARCCA experts who were hired for the federal grand jury, testified in the first trial. Remember, the Commonwealth is saying, we need more discovery. We would like more information. And the defense is like, yeah, how does that feel? Are all of you watching one of my favorite TV shows in the world, Traitors? It's kind of like when at the beginning of Traitors this season, Tom Sandoval was sitting down with the, eminently fabulous Alan Cummings and said, hey, so Tom, if you weren't a traitor, would you feel betrayed? And Tom's like, yeah. And Alan's like, it's not a very good feeling, is it? This is how I feel. You'd like discovery? Yeah, it's not a very good feeling, is it? I'm just mind blown that the Commonwealth also doesn't have discovery. But they're like, well, we need more discovery from the feds, and the feds are like, we don't know her. The feds are like, miss us with this conversation. Leave us, get our names out of your mouth. We don't want to talk about you. They're just
The FBI.
The FBI's not impressed. They don't want to hear about it. All right, let us continue on with the. Meanwhile, EDB has the soap opera soft glow lighting. It's the camera on my laptop plus the door. This is all we've got. This is all we've got for the door. All right, let's continue zooming together until we get to the end of this seemingly extensive sidebar. Hopefully it's not, I mean, we're going to buffer just a little bit. I'm going to see if we can zoom. It's gonna, okay. Jackson's back at council table. Yanetti's back at council table. Brennan's back at council table. We should be back.
Hear you, Mr. Brennan, on your motion for reciprocal discovery.
Oh, the laptop's intentional. I see now.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCCA experts.
So-called, sir?
Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are...
The so-calling, the experts, that is just incredibly frustrating. Because we watched the experts the Commonwealth put up, and then the experts that were hired by the feds. And I don't think there's anything so like coroner armpits we can have a conversation about. I'm open to that discussion. Do not come for the ARCCA experts, because the ARCCA experts are not so-called experts. What the Commonwealth just said is they have finished their discovery obligations. I mean, pending the other download that they just talked about. And now they are ready for reciprocal discovery. And with them being ready for reciprocal discovery, they're like, okay, we've finished it, except for the so-called experts. The feds have to turn over that discovery. The defense doesn't have it. I'm not here for disrespect to the experts who seemed imminently well qualified after I saw the pirouette testimony. I'm just not here for it. There are some experts sometimes that are so-called experts. These are not the ones. These are not the ones. Nope. I'm not here for the disrespect. I'm just not.
That the defense comply if they expect to call these witnesses at trial.
And you've asked for, you have specific requests.
The FBI, did the FBI tell you to fuck off?
For the discovery, right?
I do.
And the FBI said, bruh, good luck.
Jackson?
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to...
We are not the audience, sir. We are not the audience for a full-throated conversation. We are not the ones. We are not the ones, Mr. Jackson, that can handle a full-throated conversation. We cannot do it, sir. We're just not there. You say that shit in Utah, we're all going to lose our minds. Okay. The argument now is not really argument. It's scheduling over the discovery and when we are getting the discovery. The fact that he's like, there are new experts, there is new this, there is new that. This is going to be an entirely different trial. which is not normally what you get in a retrial. What you normally get in a retrial is like trial 1, take 2, and it's very similar. The fact that we have gone all new everything is going to be so much. And I see you, Chad. I didn't mean the disrespect. I feel like I need to say for the replay crew that the chat would like the replay crew to know that they can in fact handle it. They are experts at handling it, and you don't even know. So chat's like, no, don't tell. We can handle it. We can handle full-throatedly handle it. We're ready for it. Chat, 10 out of 10. My apologies. So the fact that there's that much new information means they probably got a lot of different experts.
Filed our motion to dismiss, I think, by the 11th, which is in 6 days from now.
They need the video.
That's a reasonable possibility. We simply cannot get it done that quickly. I would suggest...
And I think the defense is right. The defense is like, look at how much new information we got, new experts, and there's this new video that exists. They're going to need that before the motion to dismiss. Because how do you argue these are all the different things that are problems when you haven't had a chance to review the things?
Pretty full-throated. The court indicated that it wanted
That was not, it was not intentional. That was not intentional. That was divine intervention. I was just trying to back up to hear more about the discovery dates and about the fact that he needs more information. That was not intentional. It just happened. I did not do that on purpose. I just wanted to hear about discovery. Damn it. I mean, I'm not mad about it. I'm not mad. We'll just do it one more time.
To dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court and urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome. Although it's going to be a very, very full-throated motion.
You said it
so
twice.
You first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss the last trial, the same thing, forecast, and then it's coming, it's coming. I need that motion in order to get it.
Ma'am, we can't go from full-throated to it's coming, it's coming. What we can't do in court today, Your Honor. Also, I lost track of what the court was saying. It just... I don't know. I don't know.
January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss the last trial, the same thing, forecast, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say.
They need more time. I agree that they need more time.
What's the extent of the information that you provided today or yesterday?
In the most recent discovery?
Yes.
It was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the...
For everyone who has just taken a deep breath and come back to court with me, I appreciate you. Brennan's not hiding the ball in this. The court is seemingly wanting to tamp down on when the defense can turn in their motion to dismiss, and Brennan is not leaning into the court's indication that maybe they want to speed this along, Brennan has said truthfully, this is voluminous discovery. We have given them quite a lot of information and is not leaning towards the court saying, hey, we can just move this along. And I think that's fair. No, Your Honor, we gave them a ton of shit. But also, why are we turning over so much information before a second trial? Oh my God.
And when I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone
and some of
investigations.
That's a lot. I'm going to go back to these categories. There are two different potential issues here. One potential issue is the motion to dismiss. The new video is going to matter for that and some of the other things. The second motion is all the motions in limine. Do all the new experts, does all the new stuff come in? And the categories of new stuff, I'm curious about, but it sounds like quite a lot of new experts.
Until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction,
right,
phone investigations. So we sent it by link because it was
accident reconstruction.
Okay.
So new
Does the
accident
defense
reconstruction expert?
anticipate evidentiary motions in this case?
Yeah.
Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Would you invert them, Your Honor? Would you invert them? That shit's flipped. And I think it's fair. I'm snarking a little out of turn here because this is fair of the court to say the court's trying to give them more time and still be mindful of the time they have until trial starts, and said maybe if we're doing evidentiary motions, we can do the evidentiary motions, then the motion to dismiss. Maybe we can change the timing so we don't lose time. I think that's fair.
I don't anticipate evidentiary motions from our end.
Really?
Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
Interesting.
How about the Commonwealth?
There are none expected.
Okay. Well, there we go. That should take some time up. What are we doing with this motion to dismiss? I'm curious.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss.
I thought he had till March 11th. Oh, no, it was February 11th. I mean, that's a
We'll
little
hear
more
it.
time.
There are no evidentiary.
It's a little bit more time.
Commonwealth, I'd like you to comply with your response, if you could, by the 27th, 28th. Oh, wait, this is March. I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th.
Okay. So she did flip it. That was the previous date for the motion to dismiss. He was asking for more time. She gave a little less time.
And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us 24th to file the motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend.
But the court needs more time.
I need weekends.
Right, the court needs...
It's not possible. So
Right.
I'm giving you from February 11th to February 20th. I'll
And
give
the
you to
court's
the
like,
21st.
she needs to review it
Okay,
too.
21st? Thank you, Your Honor.
Commonwealth, I'll give you to the 28th.
So everybody got
Okay.
bumped today.
Thank you.
All right.
So Judge, are we taking off 218?
We're going to take 2/8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of...
February. You were supposed to be here anyway on your motion to dismiss.
Okay. Okay.
I like that they're
I'll
doing it
discuss
before
with,
trial.
Mr. Brennan.
All right.
Okay?
Thank you all.
Your Honor, may I?
Yes, I'm
Oh.
sorry.
I thought we were
Few
done.
things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been
Yes.
a date sent. I'd like to...
All right,
ask-
so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's an extra copy? Okay. This one, if you want it. Awesome. Thank you. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
He wants to make sure the date is set. I think that's fair.
All
It's
right.
like, can we set a date, please? We need a date.
So all reciprocal discovery be provided by March 6th.
All right. Anything else?
All right, thank you all.
One last...
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
I like that the whole courtroom laughs when he's like, excuse me, Your Honor, just kidding. Your Honor, no, one more thing. Wait, one more thing. Wait, Your Honor, one more thing. One more thing. And of course, we've got the zoom wheel of destiny. So they go to sidebar and then court is ended after this sidebar. So court being ended after this sidebar is where we are at. So let me just zoom through that real quick. But it looks like court just ends right after that sidebar and just that is in fact the end of the world as we know it. I feel fine. All right, let's try to do a summary. No, let's not do a summary yet because chat, you let me know that, but wait, there's more. So let's, but wait, there's more, and then do a summary. How does that sound? How does that sound? All right. But wait, there's more. And I'm going to take a look at that real quick because, well, chat, you let the moderators know and the moderators grabbed it for me. So did the court already rule? It looks like she did. Did I look at that until now? No, because we said no spoilers and that included me. So let me pull this up. Thank you to Miguelina and the moderators and Leonards for those of you that said, hey, by the way, there's a thing. Fantastic. Thank you for the heads up that there is a thing. So let's do that and then we'll do Q&A. Chat, are we ready? Emily, change your screen share so we can see the thing. So we can see the thing. We need the thing. All right, there we go. The thing is ready to thing. So let's all look together at WTF happened. Because I don't know. Here's the thing. All right. Does that look full screen? No, it does not. Can I make that bigger? Hopefully. Let's do that. Nope. In biggin. Voila. Okay, so this is February 6th. This is decision and order on defendant's motion to recover expert-related expenses from the Commonwealth. After hearing and reviewing the pleadings, the court credits the affidavit of Special Prosecutor Hank Brennan, paragraph 6. Okay. Quote, Attorney Jackson expressed concern that the materials may no longer exist on the police department DVR and VR given the time that had passed since the event. I agreed with him and told him I had no knowledge whether the materials still existed or were overwritten given the passage of time. Well, we can see why the court's denying it then. In light of the averment of ADA Brennan and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennan discussed his concerns regarding the likelihood of the video existing, the motion to recover costs is denied. Further, though Attorney Jackson argued for sanctions for an alleged violation of Massachusetts Rule of Criminal Procedure 14, there is nothing in the written pleadings raising that argument, and the issue is therefore not currently before the court. So moot, but it will come up, I'm sure, in a separate motion. Defendant's motion to recover expert-related expenses is hereby denied. I'm not sure all of you are going to feel good about that ruling. However, the thing that is going to stick out to the court in that is that when Jackson was pressed on, did you have this conversation with Brennan, where both of you expressed concerns about the existence of the video, he did not deny that and did not say, no, Brennan told me that it was there. The defense saying we want to see anyway is a choice. That's not them being misled. So if Brennan had said, which is what the defense originally argued, if Brennan had said, yeah, come out and get it, sure, of course, and they got out there and it wasn't there, that is a different circumstance than Brennan saying, I have concerns that this, what you're seeking does not exist, but if you want to give it a try, we're going to allow you access. We'll allow you access, but we don't say that we've not told you it's there. I don't think it's there. I have concerns that it's not there. And giving the defense that heads up means it's a choice, not that they have been induced to do something where Brennan had told them, yes, it's here, come get it. It was, we don't think it's there, but you're welcome to come check if you choose to. That's what this issue comes down to. That's what this issue comes down to. There will be other motions, and I think we'll probably see a motion for sanctions. There will be other motions. So let's do a summary so I can answer some of those questions, and then we'll do some questions, and then I'm going to roll. Then we're going to roll. We have got to go. So let's do a summary real quick. Where is my swoop? At the end of the hearing today in Massachusetts, we did learn some interesting new information. First, the court took up a number of matters in just a little over an hour today in Massachusetts with regard to the Karen Read case. The biggest matter that the court took up today was the defense's motion for expert expenses, where the defense argued that the Commonwealth led them to believe that there was information at Canton PD on the original DVR system with the different video cameras from the overnight when Karen Read's SUV was brought into the Sally Port at Canton PD, and they wanted to download that video with its metadata from the original format. And then when they got to Canton PD, everybody was like, this isn't here. And the only reason they spent the money to send their expert is because they believed, based on conversations with the Commonwealth, that that existed. In the Commonwealth's response today in court, and I have not reviewed with y'all their written response, but in the Commonwealth's response today in court, the Commonwealth said, and the defense did not deny, that Hank Brennan, the special prosecutor, said, I have concerns that this does not exist on the DVR. I think that this has been overwritten. I don't think this is still there. And Alan Jackson said, I have those same concerns that this is not still on the DVR. If that is true, then did the defense make a choice in saying, we're going to send our expert anyway? And when we finish with the hearing, because law nerds are bae, y'all let me know that the judge had already ruled today, which colored me surprised because this judge does not rule regularly from the bench, but does in the last 2 hearings has ruled very quickly in time to when the hearings have happened, which is not what we saw before. So Judge Cannoni denied that today and said very specifically it was based on ADA Brennan's representation that ADA Brennan expressed to Jackson concern that did not exist and had been overwritten, and therefore, again, the defense made a choice. It's not, oh, it's here. The defense shows up and goes, well, where the fuck is it? It's, I don't think it's there. You don't think it's there. But if your expert wants to come access it, we'll give you access. That's your choice on how you decide to prove your case. But what we did learn that is going to be an issue, and perhaps a large one for a different day, is that not only did the defense expert go out to Massachusetts and wasn't able to download anything from the original DVR, but then we learn that I just saw, is my audio skipping? It's the Wi-Fi. Sorry, y'all. It shouldn't be, but clearly it is. Hold on. Let me check. Nope. We're still well connected. I apologize for the stutters. So what we learned today new is that after the defense expert came out to Canton PD and couldn't download anything, Brennan went and had a conversation with somebody who's retired. And that when Brennan had that conversation, they found that a detective had downloaded selected videos and had saved those on a hard drive and perhaps some type of iCloud or cloud account. So there are some selected videos that were downloaded, and Brennan said very clearly in court, I don't believe that there is an exhaustive and entire download of video from the Sally Port from that relevant period of time, January 29th, 2022. We don't think that exists. And so someone downloaded selected videos from the Sally Port, and the defense doesn't have all of those yet. And that is wild to me. So we are going to see the defense making a motion to dismiss. We might see the defense making a Rule 14 discovery motion or motion for sanctions together. So we're going to see more motions about this. Today was not the day to fight all of those different battles. Today was just about the fees that the court denied. But there's a lot more information that we need about who chose to download selected videos and then save them on some hard drive or somewhere that weren't turned over to the defense before the first trial. Where did all this video just live? So for all of you that are going to ask, and many of you will, how is this any different than Santa Fe police putting, ammunition? It was actually ammo, Emily. These don't mean that. Putting ammunition under a separate case number and being like, oops, we didn't think it was relevant to this case. There is so much more information we need. I'm looking forward to seeing the motion to dismiss and response to the motion to dismiss to learn more about this. It seems that when Brennan came onto the case, Brennan discovered more video that had never been turned over and turned that over. It seems that when Brennan came onto the case, he also discovered that there was discovery that the Commonwealth didn't have. And was like, where is this information? Including information from the defendant's phone that they are going to have before the next trial that the Commonwealth didn't have going into trial. Like, the Commonwealth didn't even make sure they had all their own discovery. And the Commonwealth was arguing again that they wanted more discovery about the ARCCA experts, though Brennan said so-called experts, which definitely got the ire I think it deserves, because the ARCCA experts I thought were fabulous. And so-called experts, you can try to throw shade, sir, but please. We also learned that the Commonwealth has turned over voluminous their words, new discovery to the defense in this case ahead of the second trial. New experts, new expert reports, new full files. So this retrial seems like it's going to be a very different case, including, it seems, a completely new accident reconstructionist and a new accident reconstruction process. So the defense got voluminous new discovery today, beginning of February 2025, ahead of an April 1st start date for jury selection. So much is going to happen in this case between now and April when this trial starts, and this retrial is going to be a completely different case. I'm still stunned at the things we learned today in court, especially about all of that video that wasn't turned over. Is there arguments to be made about dismissal? Yes, we'll talk more about it. We'll talk about whether this is exculpatory or whether it's just information that can be used to impeach witnesses. We'll have that discussion. We'll talk about what the case law, because it's going to be in these filings, the case law in Massachusetts regarding a motion to dismiss, regarding Brady, and regarding whether or not there were discovery violations here. We're going to see all of those arguments. And as the attorneys make those arguments, we will have enough information to argue it, because right now I don't have all the information. I have a lot of questions, and I do not have confidence that there aren't some very large problems here. What will happen with those, we will see, but this is advocacy. I want to see what both sides argue with regard to the motion to dismiss and the timeline. And though there are times I do not appreciate Brennan's snark at experts that I liked during the first trial, because, sir, how dare you? Sir, how dare you? But I also think Brennan was fairly upfront with regard to how the discovery shit show happened, and seemed to be very like, this happened, then this happened, then this happened. This is what I told the defense. This is what's happening now. He didn't seem to me to try to justify or excuse it as we got to the end of the hearing, but tried to explain the process he went through. The Commonwealth should have gone through that process 2.5 years ago. But at least he said, this is what happened since, this is what we discovered, these are my concerns. That can be kept out at a new trial. That could be Brady. The defense is saying that it is, but the defense hasn't even seen all of it yet, so they're not going to know if it is or if it isn't. But there's a lot more to this case as it gets ready for trial. That the fact that the Commonwealth's like, we don't have all the discovery from the defendant's phone. So why are we filing this case then? How are we at a second trial when they don't even have all the information from the defendant's phone? What is happening? This case is wild to me. Wild to me. This shouldn't be happening. This shouldn't be happening so late in the game, but it is, and we will see. I'm going to cover all those motions when they get filed. I want to know. I want to know. I want to know. I'll say it full-throatedly. I have so many fucking questions. And trials in 2 months. These attorneys are not going to get a lot of sleep. No, they're not. No, they're not. No, they're not. Not a lot of sleep. Not a lot of sleep at all. All right, Law Nerds, let's get to some Q&A, and then I'm going to get back to travel things. So, Law Nerds, you have questions, I've got questions, we got questions, let's have questions. Questions, bumper. It was like, bro, fuck yourself. I'm not bumping the bumper. Bump. It froze on my end. I don't know if you saw the bumper or not. It froze on my end. That's letting me know exactly where the internet is. The internet's over it. The internet's over it. The internet's over it. We're going to try one more time. Bump, bump. Oh, what is happening? What is happening? Maggie P in the chat said, what is happening? I've been asking myself that a lot recently. What is happening? Truth Seeker said, what would it take to dismiss? Generally, you're going to need a violation that cannot be remedied before the new trial. So that is the one thing I'm focused on, is what is the evidence? What has been turned over? Can it exist? Can it not? So we will see what happens. Let's get to a few of your questions because I know you have them. And if they are questions about, isn't this Brady? I want to see what the things are because they don't know all the way. Let us see. Crime Time said, what is a notice of compliance? Like what we saw in New Mexico, it is the Commonwealth saying, I am giving the court notice and the defense notice that we have complied with all our discovery obligations. You have everything. You have everything you need. Everything is turned over. All the things. CSTers, we are working on more Law Nerd meetups. It is something the team and I have been working on. When I'm doing quick travel, unfortunately, we just do not have the bandwidth to do it. But we have been working on organized and set up meetups with the Law Nerds so that they are a good experience and everybody knows what to expect and we know where we're going to be. But when I'm just doing quick travels, we do not have the bandwidth to make sure that we've tried to do spontaneous meetups and the Law Nerds show out in force and then we get kicked out of hotels. So it has to be a planned thing, but we will be doing some of those in the coming year and into next year. Lori said, how is it that Officer O'Keefe's brother always gets that seat? I think that the court has decided where the victim's family sit and where the defendant's family sit, and then the family has that row, and then they choose. So, comes now, volume 69, full-throated motion. And the judge is just like, and it's coming, and it's coming, and it's coming, and you keep saying it's coming? Yes. Yes. For those of you asking, did I finish Onyx Storm? Yes, I did, and I am immediately rereading because that's where I'm at. Immediately rereading. That's where I'm at. Basking in it says this needs to be dismissed. This is just insane. It's a lot. Oh, it's a lot. I need more facts because I'm not going off of vibes. I have a lot of questions. I really have a lot of questions about what is on those videotapes, what was selected, what wasn't selected, how without a chain of custody this came into the first, I have so many questions, but I think that at trial, the inverted video actually hurt the prosecution more than keeping that video out. It looked like just absolute fuckery. So I think it actually did more damage than help. I don't know what the prosecution trying to say oh, but see, nobody's back by that taillight. And then the defense coming in and being like, that shit's flipped. So they are by that taillight. I think to a jury that just looks really bad. It looks really bad. The Commonwealth hiding the ball does not help. Music to my soul. Yeah, the judge did rule from the bench today. I mean, it had been under advisement though. It had been under submission. So it was like yes and no. But it was. Stephen, good to see you. Heavy on what was Lally doing, right? What was happening? It's incredibly frustrating. Icigal, I probably got that wrong because my brain can't tell where some of the letters are, and I apologize in trying to read and pronounce appropriately, but this is a great question. Why is the issue only about reimbursement? It has to be paid, of course, but isn't the incident scary enough to dismiss the case / to accuse some so-called, quote, human beings for murder? What's next? Not just being paid. The court only takes up motions that are before the court, and this court does that in briefing. So if they brief one issue, you do not get to bring up all the other issues. You only get to bring up what was briefed. And they only briefed the issue of the reimbursements. They have other motions coming. Apparently, you keep saying it's coming, to quote the court, on the motion to dismiss and with regard to any potential discovery violations. So that is going to come up. So that is why the motion was only with regard to the expenses. And more came out after they made that motion. So now they have even more potential grounds for their motion to dismiss, because now it's like, well, some dude said they saved some videos, some hard drive, some place, somewhere. So now the defense has more information to work off of. But it's real frustrating. Rhea's son, same question. Couldn't she just dismiss now based on this? No. It needs to be briefed. It needs to be evaluated. And the court is going to want to know, what exactly does the video show? What does each of the videos show? What is on them? What metadata exists, doesn't exist? What has been recovered? What hasn't? There's more facts needed and full briefing. And that's really what the court is going to wait for. Kate asked, isn't it Brennan's responsibility to ask the police if it's still there? Yes. And it seems that what he said was, I don't think it's still there. It seems that that's what he said to the defense. I don't think it's still there. But we never heard Alan Jackson say that's not what Brennan said to me. He never denied that that's what Brennan said. So that's why the court denied that motion. Let's see. HP said, this is the nicest I've seen the judge to the defense. I think she's also mad at the Commonwealth. This court, I think, has got to be tired of the fuckery. So who is this mysterious now retired individual who has a personal detective file brought, right? He just downloads stuff. Oh my God. It's so frustrating. It's so frustrating. Elaine in the chat said, breathe, Emily, there's more. Oh, today went off the rails, but we learned a lot. We learned a lot. Jackson should start his opening in the second trial with a lie unchecked becomes the truth. I mean, the magic shade of a lie unchecked becomes the truth in an opening statement. It would be a magic moment. Casey Cat said, just when you think this shit show couldn't get any worse, Brennan speaks. I think there were times today where he was way too hyperbolic for my taste. And it's 5 o'clock. I think there were times where he was way too hyperbolic, but I think there's times where he was very transparent. And I appreciate that at least when he was being transparent, he was just like, this is the order of events. And I appreciate that. The order of events shouldn't be going down this way, but at least he's saying this is a problem. And didn't deny it was a problem. And Alan Jackson did the same thing today too. There are times Alan Jackson is more, maybe more hyperbolic than is helpful. Like this level of hyperbole is unhelpful. There are moments when Jackson is very much not talking to the court, but talking to all of us. And when it came down to the request about Karen Reed's phone, Jackson was like, Your Honor, that's squarely within the search warrant. We're not arguing over stuff that doesn't matter. And I hope that we see that in the coming motions, that we see them focused much more narrowly on the issues. And I think with Brennan and Jackson, we're seeing some of that is, yes, there's hyperbole on both sides. Yes, there's frustration. It seems on both sides. I understand why the defense is so frustrated. I'm sure that Brennan is also frustrated that this should have been done way before he came into this case, but also, how do you not know that this is what's happening? But we are seeing them narrow it down to some of the issues, and then when there's no real dispute, not disputing it. And I appreciate that. Yellow Pill asks, has Lally been in court on all these proceedings? Yes, the court has said good morning to him, and he's made his appearances in all of this. Ariana Barnes in the chat said, what bothers me is that regardless of innocence or guilt, this case is so botched that we may not know what really happened. I feel sorry for the families, but I'm baffled that this was ever brought. It is exceedingly rare that we get to the very end of an entire trial and go, what, if anything, did the Commonwealth prove? And it's a frustrating case because everyone in this community deserves answers about what happened. And we do not have answers. And that is incredibly frustrating. just incredibly frustrating. I don't like getting to the end of a trial and being like, there's a lot of possibilities, but for the defense, that's doubt. Like, there's a lot of possibilities, and that's doubt. I'm interested to see how the defense navigates that in the next trial. I don't know. I don't know if it helps for the defense to try to shift the burden onto themselves. I would like to see them putting more spotlight on what did the Commonwealth actually prove to you? What did they show happened? Like, for real, for real. What do you know with a moral certainty, which is what it says in Massachusetts? What do you know with a moral certainty? Trish818 said, why is it up to the defense to provide discovery for the ARCCA experts? Shouldn't it be the AG? Because they are the defense witnesses. And so the issue is that the defense is calling them, but the AG hasn't given the defense the discovery. And so the Commonwealth is like, well, we don't have the discovery. And the defense is like, right, neither do we, but these are our experts, so we can voir dire them, but that's about all we've got because the AG is not turning it over. And the court is not going to block those experts based on Rule 14 discovery. That's why the court had a voir dire on those experts. Okay, well, we'll just do the discovery now because the AG's office isn't going to turn it all over. And if, hear me, Lawnards, if this is speculation, I don't know if I have chimes. Emily, do we have chimes?
The FBI!
Not chimes.
Bring the jury.
Not chimes. Nope. There they are. If part of the investigation into this case is targeting law enforcement, the DA's office, particular DAs, if the federal investigation is targeting any of those things, then it does not shock me that the AG's office would be hesitant in all they turned over. Because grand juries are secret, you don't want to always give your targets what's happening. If, and I'm not saying that's true, I'm saying if that is part of what's going on, then what the AG's office is willing to turn over could be limited based on what they ask the experts to do. If the AG's office said to these experts, the Commonwealth says that this, and I'm not saying they do, this is me talking through the thought process with y'all. If the AG's office said to the experts, our question for you to determine are these things. Did John O'Keefe get hit by a car? Did John O'Keefe get hit by a Lexus? Did this happen the way the Commonwealth said it did? Are these things consistent or inconsistent? Any of those questions could potentially give any of the parties indication of what way or what target the grand jury is looking for. So the ARCCA experts giving a overview of, we were asked to evaluate this case and give our opinion about whether or not the victim was hit by a car, really pares down that ask and really narrows down the way that you might glean information from the questions being asked. And so the AG's office is like, these are the individuals that were hired to look at this, and this is the determination about whether or not the victim was hit by this car or hit by a car like this. And that narrows it. So that might be part of why the discovery is not being all the way turned over, because the AG has their own investigation. And it is I can't express enough what an odd situation it is to have a state-level criminal trial going on while we know that there is a federal grand jury investigation into at least the same case. I don't know. So, Grassfolk, thank you for the lovely compliment. What should be in the motion to dismiss versus the argument? All of their case law and then the specific items of discovery that are at issue. That is what I'm looking to see in the motion to dismiss. Lindsay, thank you for the gifted memberships. Lee, thank you for the gifted memberships. All the new members, welcome. We're going to have much to talk about this Members Only Live because being at Jelly Roll with my friend Amy Van Dyken, who is amazing, and then like her and Michael Phelps just like having all of the chitty chat and me being like, look at all the Olympic swimmers. This is My life is surreal. It was a whole day yesterday, and we'll talk about that more. Tori, thank you for the gift of memberships. DK said, can she rule new trial, new evidence, new rules? D, yes and no. If there's room to remedy the issue, remember, dismissal on a Brady violation, dismissal is the most extreme remedy. There are other remedies. However, if there are things that are destroyed, it is very difficult to remedy things. So it's not we turned it over late and here it is, and now there's time to address it before the new trial. This seems to be more of an issue of destroyed evidence, but I'm interested to hear from the defense what they have access to, what they don't have access to, and whether or not just keeping all that evidence out is the actual remedy for the new trial, or if it can't go forward. Nishay asked, is Amy Van Dyken as cool as she seems cooler? She is exactly who she is. And she is amazing and funny. And we curse a lot. Good times are had by all. We're also all on the same page of like, we'll take a cute photo together at the beginning of the night because we were together. And then like phones go down and we're just going to like have the experience that we have and maybe video a little bit of Jelly Roll singing, and that's about it. And then we're just gonna boogie together and have a fun night. And that's a lot of fun too, I haven't been on my phone much. I know there's stuff I'm gonna have to catch up on. It's gonna be on the plane ride home because it's been just an offline kind of couple days, which is fantastic for me, and always needed to take some time to just be IRL with the IRL friends. So it's good times. It happens too rarely, and travel this year is going to be limited because of the amount of trials we're covering. So that is frustrated. Really, really frustrating, the amount of trials we have. But this is today. It's just wild. It's just wild. So, Lonards, I'm looking, there are so many super chats. I know I'm not going to get them all. To everyone who shared updates on all of the life things, I have seen them. I am so glad for all of the updates. Glad that people are doing well. Saw a few like congratulations for new like Lonard babies and grandbabies and surgery recoveries and all of the things. You guys are fantastic. I know I'm not going to get to pull them all up, and we are starting to exceed the limits of my strength. Wi-Fi crashed. As I was saying, as I was saying, all of the Wi-Fi crashed. I was trying to wrap up and say we've probably exceeded our limits on the Wi-Fi crashing, and then it all just went. Vroom. Thank you, Lonards. We'll fix it in post. We'll fix it in post. That is my cue to say goodnight. Lonards, it's great to see you. We got to go through this hearing. There is no quick bits for Monday because I'm not recording while I am doing the things. We will have lots to cover on stream next week. Don't you worry. I've got you. We have so much to cover next week. But for now, enjoy yourselves. Enjoy your weekend. I will enjoy mine. I will see you live on Tuesday. I will keep you up to date in the chat. in the Lawnerd app, and I will probably take a vote on what we cover when to see what you guys are most interested in covering first. For all of you asking, Emily, are we not covering every twist and turn of the Lively Baldoni at all? Look, first of all, their lawyers are all exhausting at this point, for real. Second of all, I have been summarizing it on QuickBits. I cannot live read 300 pages. It's just not going to happen well. I'm just going to be annoyed. But I have been summarizing them on the Emily Show, on your favorite podcasting app, on the QuickBits channel. So if you have the Lawnerd app, you'll just know when those videos drop. And then we will be back covering it on stream as we can summarize things together and kind of look at highlights. But there's no way to cover line by line all of those motions in a reasonable sanity for me, because all the attorneys have gotten so hyperbolic. But I think we're going to see that toning down after the last hearing, which I covered on this week's episode of The Emily Show, in the Lawnerd app, on the QuickBits channel, in your favorite podcasting app. We've got it. Next week, I will see you. We're going to have to do all of the things. But next week, I will see you. So, Lawnards, take care of yourself. Take care of each other. Thank you for being a Lawnerd. Good to see you. Good to see you this week. And I will see you soon. So I'm going to roll that outro, and we're going to say goodbye. It was good to see you guys. Have a good one. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnerd.